Good evening, everybody. Thank you very much for joining us. Thea, are you able to put your camera on now? Thank you. Hi. My name is Jerard Ross. I'm one of the medical legal advisors here in the MDU, and tonight I'm delighted to be joined by Miss Thea Wilson, who's one of the barristers working in 12 King's Walk. What we're going to talk about this evening is consent, something that comes up relatively frequently for our members and is always a bone of contention. There's lots of cases that we all hear about, that we all are aware of to greater or lesser extents, that impact on our practices. So we're going to talk through some of the more recent cases and hopefully help you in doing your job. I did quite a lot of consent, as we all do. In my previous job, I was a consultant neurosurgeon, so talking to patients about very serious interventions was very common. But we all do consenting, whatever our roles as doctors, when we're dealing with patients. So it's something I think is very relevant to all of us. So my day-to-day job really talking about advising doctors when things are going wrong, or trying to avoid things going wrong. Sometimes things are so wrong that I need to instruct solicitors to help them and me manage the situations, and sometimes we even have to instruct barristers or advocates in Scotland to help the solicitors help me and the member. And for that reason, we've got Thea here this evening to talk about her understanding and experience of consent. Thea specialises in clinical negligence and personal injury claims and in inquests. And in fact, she sits as an assistant coroner in Essex. In terms of her clinical negligence work, she splits it 50-50 between claimants and defendants. So it's possible that she could end up even defending one of us or one of you, because she does work for both NHS Resolution and for the MDU at times, providing assistance to our members. So welcome, Thea. We're delighted that you've agreed to share your experience and insights with us. Just to say a couple of things before we go on. Thea is a barrister, and therefore she works in England, but much of the law around consent in the United Kingdom is similar in the different jurisdictions of this United Kingdom. In fact, a number of the cases that we're talking about that you'll be aware of are cases that started in Scotland rather than in England. Whilst there are some slight differences in some aspects of how we approach things around consent in the different jurisdictions, I'm thinking about things like capacity. When I say that, the general approach to consent itself and the law around it is pretty standard. And of course, the GMC regulation is exactly the same. There are a few hundred of you here tonight, and in my experience, often people leave their questions to the last moment, which is fine, because obviously you're getting a lot of information and you might take a little while to distill the questions out, but it does mean that it can be a struggle for me to get to the questions, to pose them to Thea and myself, and to try and answer them. So if you could try and put your questions in earlier rather than later by using the questions part of the GoToWebinar box. The more clear and short the question is, the better the chances are that we'll be able to address it. Clearly, if you have a complicated issue that you need to get advice on, then please do contact us in the normal way, through the website, through email, or through the phone line. We're here to help you 24 hours a day. You'll be able to download an attendance certificate for tonight for your appraisal after you've completed some feedback for us. So please do that if that's okay. When I was thinking about consent, I went in and had a look through our case files. I've just pulled some data from our own case files on consent. The numbers are commercially sensitive material, that's why it's not being shared, but you can get an idea the sort of things that we see. Problems relate to consent itself, to consent forms, to resuscitation. Lack of consent there, that actually usually are cases arising from somebody claiming to have been examined or touched inappropriately and complaining about the doctor. So we see consent coming up in all of these kinds of areas. When we look at the NHS resolution data, and this is publicly available data, these are not MDU claims. As you know, most of your hospital claims, and now in England and Wales, GP claims are managed by NHS resolution. So between 2009 and 2019, or 2019-20, there are about 102,000, 103,000 claims against trusts where failure to warn was one of the heads of negligence. Thea, please step in if I'm getting anything wrong here. There were about 10,000 claims against general surgeons, about 15,000 claims against orthopedic surgeons. We haven't gone into the GP claims because obviously there was a change in this time between MDU and the defence organisations providing indemnity to NHS resolution, so we don't have that data. But we know in other specialities, like anaesthetics, for instance, it's much less. So I think there are something like 87 claims in the same time period. In terms of looking at the GMC cases, we don't have a lot of data about how often consent features. But I would say that we probably have seen a slight change in the number of claims about consent, probably since the Montgomery case. Thea may be able to talk about her experience of that. And anyway, with that, Thea, can I hand over to you now to talk us through things? I'll hide my camera.
Thank you, Jerard. I'm just going to share my screen with you now. Right. Well, thank you very much, Jerard, for that, and good evening, everybody. I'm going to be talking about informed consent and the law around informed consent. And the topics I'm particularly going to look at is just the legal background and the developments in the law of consent over the last 50 years, including the judgment in Montgomery, which I'm sure everybody has heard of. And then, as advertised, I'm going to focus particularly on the last year's decision in McCulloch and Forth Valley Health Board. And then I want to spend some time dealing with really practical takeaway tips that everybody here can use in their practice. What I'm not going to be talking about tonight is questions of capacity and circumstances where someone has refused consent, which is a question often of the Court of Protection. If there is a disagreement between the doctors and the family on the best course of action if a patient without capacity is being dealt with. I think that's probably a matter for a full talk on its own. So starting off with where we were, I put a couple of quotes here. The first is from 500 BCE. The other one is from 1985, but historically, there was a very paternalistic approach to patient care and patient health and to obtaining consent. Very much the attitude of the courts was that doctors really too much information just allowed the patient to make a mistake. And really the doctor's view should be trusted. And I think the pattern of the last 50 years or so has been a move away from the paternalistic approach into a more advisory and a more dialogue-based approach. But I'll go through the history to start off with, to show you where we started out. So some of you may recognise this hospital. It is the just getting up. It's the Friern Hospital. It's where the events of Bolam, which anybody who's looked at any medical law probably has heard of, took place. In Bolam, the principle of negligence in a clinical negligence setting was set out. And from Bolam, we get the principle that if a responsible body of medical opinion would have done the treatment, even if it wasn't necessarily the best treatment, even if a responsible body of opinion would have done something different, that is still not negligent. Now, that's the principle that we've been using in clinical negligence law ever since, as refined by Bolitho, which adds the clarification that that must be logically defensible. And that was first sort of put into dealing with the law of consent and informed consent in the case of Sidaway. And here we have the Bethlehem Hospital, which is where the events of Sidaway took place. And Sidaway took the Bolam test and the Bolitho and put it into the question of informed consent. And this was in 1985. And this is really the starting point when we're considering the law of consent, and what certainly I came to the law, and I suspect many of you will have come into the practice of medicine understanding the law of consent to be. And that was that there was a two-stage test. First of all, was the admission accepted as proper by a responsible body of medical opinion? So would a responsible body of medical opinion have not told this patient about this? Does that stand up to logical scrutiny? If so, no negligence. Unless, and their lordships in the House of Lords added a proviso that if the patient had demonstrated by means of questioning that they were highly educated and wanted to form their own judgment, that would be an exception and they should be given more information. Now, I tend to see this as the law lord exception, because of course the law lords themselves would have wanted more information so that they could give their proper informed consent. But in the general public, as long as a responsible body of medical opinion wouldn't have told the patient, that was not negligent. Now, over the years, and coming up to Chester and Ashfar, which was in 2004, this was sort of refined, and we came as lawyers to see that if someone has been given all the risks over 1% likely, then they've probably been told everything. If a risk is less than 1% likely, they probably don't have to be told about it. At around 1 or 2%, they probably do have to be told about it. And that really, in the late 90s and early 2000s, how it came to be seen. Chester and Ashfar changed it very slightly and really dealt with the question of when a patient with a 1 to 2% chance says they wouldn't have the surgery but would have had it later, well, what would happen then? And in that case, the House of Lords held that the claimant could succeed because if they had the operation at a later date, their risks and their chance of developing that complication would have only been 1 or 2%. So looking at the balance of probability, it was more likely than not that they wouldn't have suffered the complication at a later date. And you can see there that even as far back as 2004, the law was changing somewhat from the very straightforward and very paternalistic approach of Sidaway. Now we come up to Scotland and the events of the famous case of Montgomery, which changed the law away from the approach of Sidaway in 2015. Now, I'm not going to go through the facts of that case, but suffice to say it was about a gestational diabetes and a very big baby, and whether a caesarean section should have been given as an option. And the Supreme Court held there that an adult person of sound mind is entitled to decide which, if any, of the available forms of treatment they would undergo. And this very much reflected the social and legal developments that had changed the model of doctor-patient relationships by the late 1990s. The events of Montgomery, although the case itself was 2015, the events of Montgomery were actually in the very late 90s. And it reflected the fact that the Human Rights Act had been passed in 1998, and raising the importance of your own bodily integrity and raising the importance of involving the patient in matters. It also reflected the fact that by the late 90s, GMC guidance actually had gone very much away from the approach of Sidaway and did counsel that doctors should involve the patient in a dialogue. So from Montgomery, the law has been that patients are to be treated as adults capable of understanding treatments, and they are the ones who make the decision to place themselves in the hands of doctors and accept the responsibility of choosing what risks to take. And the question since Montgomery has very much been that a doctor has to consider what the material risks are and must make sure the patient is aware and take reasonable care to ensure the patient is aware and understands the material risks of any recommended course of treatment and of any reasonable alternative treatment. And that includes the option of doing nothing at all. So what is a material risk? Well, as I said, in the 90s, in the late 90s, early 2000s, we sort of saw it as, well, it's if there's a 1% risk, it's material. If it's under 1%, it's not material. We've moved away from that with Montgomery. And in that case, and this is a quote from the case, their lordships held that whether in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. So what would a general reasonable person, just a person you might meet on the street, attach significance to? What would the doctor, if they were undergoing the treatment themselves, attach significance to? And then are there any features of this particular patient which suggest that they might want to know more about a particular aspect? For example, in Montgomery itself, the claimant was, the mother of the claimant was very engaged and very concerned about the possibility of a big baby, and was asking a lot of questions that suggested that she would have had and wanted to know more about the risks than perhaps a typical patient. So one more element in the where we were aspect, and this is the case of Deuce from 2018, and here again is the hospital where that took place. In Deuce, it was a gynecological case, and the claimant underwent an operation, and forgive me, the patient underwent an operation, and there wasn't an understanding that that operation carried a risk of chronic pain developing, and the court held that although the chronic pain did develop, there was no negligence because a clinician couldn't be expected to inform a patient of a risk that they reasonably could not be taken to have been aware of. So in that case, the question was, well, the expert evidence said that it was reasonable. A reasonable body of medical opinion simply wouldn't have been aware that this operation came with the risk of chronic pain as a result of the surgery, and therefore it was reasonable not to warn the patient of the existence of a risk, even though there was a body who were aware of it in 2008. The court, and perhaps this had something to do with it, the court considered there was also abundant evidence that even if she had been made aware of the risk, the claimant would have proceeded with the operation at that time in any event. So that's where we were coming into 2023. The questions to ask when considering consent taken from Montgomery and Deuce are first of all, what are the known risks associated with an operation? Now that was considered by the court to be a question of medical evidence and expert medical evidence. And then what should the patient have been told? That's a question that depends less on expert evidence and cannot be determined by that alone. What risks were material? And that's going back to that test in Montgomery. So coming into 2023, we have the Scottish case of McCulloch and Forth Valley Health Board. Now, I want to concentrate more on the practical takeaway, so I'm going to go through the facts quite briefly. Essentially, it was Mr. McCulloch was a 39-year-old man. He came into hospital with severe pleuritic chest pains and worsening nausea and vomiting. His test suggested he had pericarditis, and he had an echocardiogram, several echocardiograms, in fact, and an ITU stay eventually. By the end of March, he appeared to improve, and he was discharged from hospital with antibiotics, only to come back the next day. There was a further echocardiogram which showed some features of collapse, but the cardiologist considered that in the absence of other features, there was not compromise. It should be compromise or cardiac tamponade there. Forgive me for that typo. But the cardiologist considered that there was not sufficient reason to be concerned and didn't consider that pericardiocentesis should be recommended. The other decision that was made was that there should not be a recommendation to take NSAIDs. Mr. McCulloch was discharged after an improvement on the 6th of April, but very sadly on the 7th of April he suffered a cardiac arrest at home, and it was not possible to revive him. So his widow brought an action with the cause of death being idiopathic pericarditis and pericardial effusion. Now, there were a lot of allegations of negligence, but really the one that the courts became focused on was the question of informed consent. And it really turned, the whole case essentially turned on whether the cardiologist should have given as an alternative treatment, whilst recommending not using NSAIDs, the use of NSAIDs. The claimant's expert witness said that a reasonable body of medical opinion would have recommended this treatment, and the defendants said they would not. So the expert witnesses disagreed about the use and whether it was an appropriate thing to have recommended. So the court, excuse me for 1 second. I'm sorry about that. The court held that there was a responsible body of professional opinion who would not use NSAIDs. And in those circumstances, and this is at the first instance, the Lord Ordinary in Scotland held that the cardiologist wasn't under a duty to discuss the use of NSAIDs with the patient if in her professional judgment it was not appropriate to use them. That was her evidence that it was in her judgment not appropriate to use them. So the law from that was therefore a doctor only had to discuss recommended treatment and reasonable alternatives, not alternatives they did not consider reasonable. So that was appealed, and the Inner House, which is the equivalent of the Scottish equivalent of the Court of Appeal in England and Wales, agreed with the approach of the first instance judge and upheld that decision. And then it went to the Supreme Court, and that's particularly important because, of course, the Supreme Court decides cases from both Scotland and England and Wales, and indeed Northern Ireland, and therefore their judgments apply to the entirety of the United Kingdom. So the Supreme Court named the approach taken by the Lord Ordinary at first instance the professional practice test, and they upheld it. They held that it was correct that there was not a breach of duty to inform if in the opinion of the clinician, this was not a reasonable alternative treatment. So Mrs. McCulloch's appeal was dismissed and she lost the case on all grounds. So importantly, well, where does that leave us? So Lord Hamlin and Lord Burrows delivered the Supreme Court's judgment, and the rest of the Supreme Court judges agreed with this judgment. Now, they advise that the doctor's advisory role involves a dialogue. The aim is that the patient understands the seriousness of the condition, benefits and risks of proposed treatment, and any reasonable alternatives. And I've highlighted there the word reasonable, because of course their decision was also that unreasonable, in the clinician's view, alternatives should not be recommended. They stated that the patient should be in a position to make an informed decision, but they cautioned that the doctor's duty is to provide comprehensible information, not lots and lots of technical information on every single risk of every single possible treatment. They cautioned that too much information is as bad as too little, so that the risks of unreasonable treatments, or in the clinician's view, should not be given. They quoted with approval this section of guidance from the BMA, which is that the doctor really that point that was made in the previous slide, the doctor's duty is not fulfilled by providing every single little bit of information, bombarding the patient with every possible treatment, however mainstream, however fringe. Too much information is as unhelpful as too little. So moving on from that, in terms of where are we now, I also want to highlight for you the GMC guidance, and I've put this across 2 slides. There's a 7-point step that the GMC recommends you take, and this is fairly easy to find on the GMC website, so I recommend you, I'm not going to go through the full 7 steps, but I recommend you take this and you have this in mind when you're considering obtaining informed consent. The GMC highlights the patient's right to be involved in decisions and their need to be supported to make informed decisions about their care. It highlights that decision-making is not just a one-off, it's an ongoing process, and it focuses on meaningful dialogue and exchange of information. The patient tells you what's important to them, and you tell them, based on that, the information that they require to provide informed consent. The GMC emphasised that patients have the right to be listened to, and that's all patients have the right to be listened to, given the time and the information and the support to understand the information. The GMC advises that doctors try to find out what matters to the patients, and so they can share that information. Doctors should start from a presumption that all adult patients have capacity, and proceed from there. Choice of treatment for care for patients who lack capacity must be the overall benefit to them, but made in close consultation with those who are close and those who are advocating for that patient. And finally, the GMC urged that patients whose right to consent is affected by law should be supported to be involved in the decision-making process. So finally, I want to go through some takeaway and practical tips from the law, distilling it down to what you can use in your own practices. So first of all, your first job is obvious. You have to reach a diagnosis. You have to identify what treatment you recommend. Having done so, identify the risks that come with that treatment, and indeed the benefits that come with that treatment. Identify, and this is all for yourself in preparation to speaking to the patient, what other reasonable alternative treatments options there are, and emphasizing again here the option of doing nothing, and what risks come with those options and what the benefits of those options are. So having got that information available to you, then the key is to enter into a dialogue with the patient. Jerard, perhaps before I go on to what's involved in the dialogue, is there anything you'd like to come in on that?
No, not particularly, other than to say that one of the difficulties I think that I hear on the phone line and when I'm dealing with doctors in cases is that a lot of the case law is developed from operative cases where doctors are sitting with a patient for quite a long time sometimes, and perhaps on more than one occasion to discuss one treatment. The reality of much medical practice in the UK is that they'll see their GP, they'll have 3 separate things that they're taking to discuss, and they'll want something for everything to be done. How reasonably, and are there any practical tips you would suggest from a legal point of view? It's quite a tough question, I think, to take away and imagine how you would deal with that. You might want to distill that one and think about that. But that's always a problem, I think, for doctors. And I do recognise that I would sit and give them information, written information. You know, they might watch a video, they would speak to my nurse, my specialist nurse, and I would write to them. But it's not the same for GPs, or it's not the same for somebody in ED or an anaesthetist seeing somebody in their pre-op clinic just on one occasion.
I mean, I think the first thing to take home, and I do come on to this in, I think, slide after next, is that the courts do appreciate that difficulty. It can feel very much like us as lawyers are here to attack and catch out doctors, and especially, I know after Montgomery, there was a lot of concern about this new approach. And I remember doing a talk back in 2015, 2016 to a number of doctors, and my big take-home tip was then it's don't panic, don't get too concerned. Actually, Montgomery is just simply the law catching up with the doctors, because this is what you've been doing for 20 years anyway. And the law does recognise, and I'll come on to it, that the situation is very different when you're in surgery, having a proper appointment, usually a pre-surgical appointment, going through a consent form, discussing the risks and benefits. I would say that there's a huge amount of assistance. I mean, in a GP setting, we've got 10 minutes, patients come with 3 problems. I think it's useful to give some thoughts to, well, this is your recommended treatment. Just quickly in your head, are there any very common other treatments, and what would happen if you did nothing? And just go through those very quickly with the patient. No court would expect you to know every single treatment for a particular condition, but say you've got a sore throat. One option may be to treat with antibiotics. One treatment may be to do nothing and see how it develops. It may be that one option might be, depending on the type of sore throat, the type of hoarseness that's caused by it, maybe we want to consider whether there's a cancer referral going to be required. Well, very quickly you might have decided as a doctor which you think it should be. But particularly in things like cold, flu type treatments, where you're considering the decision between antibiotics and doing nothing, that would be an obvious one where you should identify the risks and benefits of both of those alternatives, whether there's any other treatments that you'd recommend, and why. I'd also suggest in perhaps many of these that there does have to be, in my experience, leaflets which often set out the risks and the benefits of potential treatments. It is always a useful thing to just keep in mind that there are these, and although you can't do a full letter and the GP practice doesn't allow you to have that kind of capacity, it's still an option. And it's just really just being mindful, I think, of the main alternative treatments. And of course, if you don't think, for example, antibiotics are a reasonable alternative treatment because this is clearly a viral infection, then the law emphasises that that's not something that it's negligent or a breach of informed consent not to tell the patient about. So that's what I'd say about that. But going on to, I think, my next slide and the dialogue. So the first thing, once you've identified, and it may well be a sort of 30-second just thinking about it. It may be that you've actually had to take some time to develop a full course of treatment, and you've had a proper time to sit down and think about the alternatives. But communicate in comprehensible language the material risks and benefits of the treatment. Think about what sort of risks would you like to know? What sort of risks would your spouse or your child or your parents want to know? What sort of risk a person in the patient's shoes would want to know about this treatment in particular? What are the benefits of this treatment? And then what about this particular patient? Is this a patient who is going to be very much, doctor, you know best, I want to do what you tell me to do? Or is this a patient who's questioning every single thing you have to say who particularly wants to make an informed decision, wants to understand the risks and benefits of everything. Your amount of information you need to provide to those two patients will have to be tailored to what those particular patients want. And then, of course, you have to consider about the benefits of your proposed course and those alternatives and communicate those as well. And then finally, the risk and benefits of doing nothing. It is something that the courts emphasize every single case, that nothing is always an option. And it often is an option that it's hard to consider. It certainly, as a lawyer, I find actually often our advice is we're just going to have to wait. We just have to do nothing for a bit. And that's not easy for a lot of clients. I'm sure it's not easy for a lot of patients, but sometimes actually that is the best course. And it is an option, at least, that the patient should understand. So the patient primarily and first and foremost needs to understand the seriousness of the condition. And I say that because a more serious condition, the option of doing nothing becomes much less a good option. But if it's not a particularly serious condition, then perhaps the option of doing nothing becomes much more important. The risks and benefits of the treatment and any reasonable alternatives. Now, that's very much, I think, what all the cases have been saying. If in doubt, your discussion should include asking the patient what they want to know about. What do they think is important? Because it may be that your patient actually hates taking medication. It may be that your patient has a terror of needles or a dislike of the idea of surgery. It may be that the patient wants to know about risks of pain but doesn't want to know about other kind of risks. It may be that this patient actually doesn't care about the risks of pain of a particular procedure but is very concerned about different kind of risks, the risks perhaps of infection, the risks the high risk low chance high risk outcomes that they want to know about. So I think that's what I'd involve in the discussion. The previous exceptions that always existed, that information would be seriously detrimental to health, this patient needs the treatment very urgently, is unconscious and unable to make the decision, those haven't been got rid of by Montgomery at all. They should be treated with caution. If you can discuss with a patient, even a patient who lacks capacity, if you can involve them in this discussion, you should. And I think the GMC guidance very much emphasizes that as well. Yeah. Jerard, do you?
No, I'm nodding in agreement. I mean, it does. Okay. It does say that. Yep. You're actually addressing quite a few of the questions, Thea, in the way.
Oh, that's really.
So this is helpful.
Great. And this is I think my final takeaway. I was trying to get to 10, but I couldn't find a way. So my final takeaway, number 9, is not to get too anxious. I think I covered that earlier. The courts do understand the pressure you're under. The courts do recognise it. The first point to make is that there's no freestanding right to compensation without an injury. So there actually has to have been some bad consequence. A risk has to have materialized before a claim could get off the ground. You can't sue just because you weren't given all the information, assuming nothing bad happened. Bearing that in mind, the courts generally recognize that most patients will accept a professional's advice. Most patients will do the treatment if that's the treatment that's recommended. And courts also recognise that every claimant in a consent case says they would never have done that. If I'd known about that risk, I would never have done that. I have never come across a claimant, and I as a lawyer take it with a huge pinch of salt. You know, I've had vasectomy case. I wouldn't have had a vasectomy if I'd known there was a risk of chronic pain. I was like, really? Okay. You signed a consent form with some risks. You signed a consent form which mentioned pain. You were anxious to avoid another pregnancy. Your partner nearly died in their last pregnancy, but you're telling me now that if you'd been told that there was a risk that you'd be in pain in 3 months, you would not even have considered signing that form. We take it with a pinch of salt. This patient is a patient who this risk materialized at. A patient going into the treatment doesn't think they're going to face a 1% risk of materializing. So we are very mindful of that. and the courts are mindful of that. So just the fact that you're facing a claim or a patient unhappy about a risk materializing does not mean that that claim is going to be successful. And of course, generally speaking, complications of a particular treatment, known complications, are not considered negligent. So that's why we got into these consent cases, because the courts have found some way for a patient who a devastating consequence has happened to get compensation. But it is the exception. It very much is the exception, and that's why I say very much still keep calm and carry on. As I said earlier, Montgomery was scary for a lot of doctors at the time, but actually reflected best practice, reflected what doctors have been doing for 15, 20 years anyway. It was just the courts catching up with what had been really a 30-year-old judgment, which embarrasses a lot of lawyers to read it now because it's so paternalistic. And I think the thing to just take home from this is just to involve as much of a dialogue as it's possible with the limitations, and to know that as lawyers we do recognize, and as judges they do recognize, that there are these limitations, that what the claimant says is not necessarily, after they've gone through, had the risk materialize, had the consequences materialize, and spoken to lawyer after lawyer after lawyer telling them what the test is, and what they need to say in order, what the legal requirements are to succeed in this kind of claim. The courts do recognise and take those with a pinch of salt.
One of the things that comes up a lot, Thea, for our doctors is the anxiety of ending up in court with one of these sorts of cases, and I'm always quite reassuring about that in terms of at least negligence, because my understanding is that the vast majority of negligence cases are settled. Before, if they get anywhere at all, are settled or fall away. So you'll be dealing with the very sharp end of the spear, the ones who actually get to court or near to court, whereas most will actually fall away anyway. Is that still the case? Absolutely.
I think the figure I usually give clients is, from the point of issue, around 99% of cases settle before even seeing the trial stage. And at trial, those are also, the trial cases are not only the ones where breach of duty is an issue, it's also the ones where causation is an issue, and it's also the ones where the amount of damages is an issue. So actually, even if you take that 1% of cases that are issued that go to trial, even those often don't involve any arguments about breach. In my experience, mostly the arguments are about causation if there is a legal argument, and then that's where most of the trial cases come from. So in my experience, an awful lot of cases settle before issue. If what we'll go through is that a claimant will bring a solicitor a claim. Sometimes it will go to me as a barrister, sometimes it won't, assuming I'm acting for the claimant in this case. But they'll first of all, before they even bring a letter of claim, they'll have to go to a doctor in that specialty, and they'll have to get a report. Sometimes the bigger firms get a screening report, which is usually very brief, but a lot of them get a full detailed report. And only if that medico-legal expert thinks that there is a breach of duty, thinks there is a failure here, will that claim even get to the letter of claim stage. Then of course it goes to the defendant solicitors, who will go and get their own medical legal expert, their own doctor in that particular specialty, to advise. Any cases where the doctor agrees with the claimant's expert that there is a breach of duty, those will be admitted, liability will be admitted, and the case will be settled as quickly and as inexpensively as possible. So it's only that small amount of cases where the claimant's expert thinks that the doctor's done something wrong, the defendant's expert doesn't think the doctor's done something wrong, that even get issued and start going towards trial. And in those cases, the overwhelming luck is usually on the likelihood of winning is usually on the defendant's side, because all the defendant has to show is that a reasonable body of medical opinion agrees with what the doctor did. They don't have to show that every doctor would agree with what this particular doctor did. They don't have to show even that it's a majority opinion. They just have to show that it's reasonable and stands up to logical scrutiny. So actually it is, it's the exceptional case that gets to court, and of those, the consent cases are the exceptional cases. If you look at the facts of those cases, I mean, Montgomery had a hypoxic brain injury of a baby. That's why it got to the Supreme Court. It's the devastating consequences cases usually that are the ones that get to court and go forward.
I'm glad that you mentioned Montgomery, and I'm glad the way you described Montgomery, as bringing the courts up to where the medical profession had been, because of course the GMC guidance described the partnership with a patient position and explaining relevant risks to them back in 2008. So I said it when I was talking to people about Montgomery in 2015. I said exactly that it really hadn't changed anything. There is a question about Montgomery. I think it's probably more for me, well, maybe it's for both of us. Somebody said, well, if Montgomery didn't change anything, why did NHS payments go up as a result of Montgomery? And I don't think I was suggesting that Montgomery hasn't changed anything. I think what we noticed after and post Montgomery was that more claims, more heads of negligence were being raised associated with failure to warn, which meant that because more were being raised, perhaps more were being successful, and given the test had moved on. So it did do something. It did result in more payouts. I think it's probably fair to say. At least I'm aware of that being the case in Scotland. I'm not entirely sure if it's the case in England, but there were certainly more money that go out. Any comment on that at all?
I'd say when I say Montgomery didn't change anything, I really mean it didn't change anything in terms of the consent process. It was a big deal for lawyers. It shouldn't have been such a big deal for the doctors, because essentially in Sidaway, from 1985 up till 2015, if we had a claimant who came to us with a lack of informed consent case, if any doctor wouldn't have told this patient about a particular risk, well, it didn't matter what the patient thought. It really didn't matter, whether other doctors would have told them of this risk. It didn't matter really how serious this risk was. And really, it was that 1% test. If it was a 1% or under risk, you weren't going to probably take the case. After Montgomery, it was a sea change for the law. It became possible really to bring consent cases in a way that it really hadn't been, except in the very rare case, the very, very rare exception prior to 2015. So us lawyers started considering seriously the cases that, as claimant lawyers, you started considering seriously the cases that previously lack of consent had very much been just a final pleading of negligence after 10 other counts of negligence. We started considering the cases where maybe there weren't any other allegations of negligence. Maybe the surgery had been done perfectly well, and it just had a recognised complication, whereas previously we would have only taken the ones where we thought actually the surgery hasn't been done well, and also the consent wasn't informed. They weren't informed of this potential complication.
Thank you. You've touched on a couple of the questions that are here, as I've said, in what you've said in your practical tips. But one of the ones that's come up from a couple of different doctors in the audience is about very rare side effects. And you did just briefly not skirt around it, but you've just mentioned it in passing. So do doctors have a duty to disclose very serious but rare side effects of let me just double check, I think the doctor's written medication. So do you want to answer that one? I can give you the surgical take on that as well. But
yeah, I mean, my view is that it's almost like a graft. It's a sliding scale. The more serious the risk, the eventuality of it comes about, the lower the risk has to be to tell you about it. I mean, if you just think, what would I want to know if I was taking this medication? Is this something I would want to know? And would it be? So if there is a risk of a potential risk of death or of some other catastrophic consequence, but that risk is tiny, 1 in 1,000, say. Well, I think if I was taking a medication that had a 1 in 1,000 chance of death, I probably would want to know about it. If I was taking a medication that had 1 in 1,000 chance of, I don't know, a minor rash, maybe that wouldn't be something I'd want to know about. Where it gets harder is perhaps if it's, you know, a 1 in a million chance, 1 in 2 million. I think that it has to be a case-by-case basis. If this is a patient who doesn't want to know these kind of risks, and it makes it clear to you that they're going to take this medication no matter what, they don't want to be blinded by all the complications, and they don't want to be terrified of taking this medication, then perhaps that's a risk that you might not want to give. If this is a patient who really wants to be informed, who's very engaged, who's very much wants to be involved in the decision process, the courts are very much emphasizing that the risk is actually the patient's to take. It shouldn't be the doctor. You shouldn't be taking this risk of this complication. The patient should be taking this risk. So I think if it's a really serious risk, I think as long as you make it clear what that risk is and how low that risk is, and making sure that risks are explained, because a lot of people don't understand percentages, but
yeah,
understanding.
I think that's a very relevant point. You know, we talk about 1 in a million, 1 in 1,000, and people buy the lottery tickets every week, where the chance of winning are much smaller.
I think you're more likely to die before the end of the draw if you buy a lottery ticket over, I think it's about 25, than you are of winning. But yeah, I mean, if say the risk might be best explained of, you know, if say everybody in the country who is taking this medication, one of these people will have this complication, or something like that. Just some way you can explain this risk if it is this very, very high risk consequence.
Yeah, which seems completely reasonable. That's how I approach surgery. So there's this. I know there's at least one spinal surgeon in the audience, and I, as a neurosurgeon, did spinal surgery, and I would approach it the same way. That very rare risk of paralyzing a patient after an anti-cervical discectomy, or much rarer still, of tearing their iliac vein, I guess, during a lumbar discectomy and resulting major hemorrhage. Those are major life-changing things, potentially, that I would want to discuss, even though the figures would be very rare. I'm conscious of time and I need to move on, because we've had a lot of questions come in, and I'm sorry if I don't get to all of the questions that we've been asked. It's not because they're not good questions. I'm an anaesthetist. I still come across a number of patients, especially emergency admissions, who say, I don't want to know all the risks and the details. I trust you, something that I do remember happening from time to time. Just what do you think best in those situations?
I think in those, I mean, your patient has told you that they don't want to know the risks. So I think they would be in a very difficult position legally. They'd say, well, they didn't warn me about those risks. I think as a matter of professional ethics, you might want to consider, well, which of these risks, if this was, say, my child coming in and saying, I don't want to hear about these things, perhaps you might want to say, well, look, you know that anesthesia comes with risks, including, you know, a risk of death, but it's very, very small. Any surgery is very serious. And then if they're making it clear they don't want to know any more details about exactly what risks there are, exactly what percentages there are, they are going to consent in any event, then perhaps you might, I mean, it depends. If you're coming in with a trauma that's going to be operated on immediately, then yeah, you're not going to be going through, take home this leaflet. But if you're perhaps prepping someone for surgery, they're definitely going to do it. Perhaps send them home with a leaflet before their surgery saying, look, I know you've told me you don't want to know about the risks. This leaflet has the risk. If later on you want to have a look at this, or someone in your family wants to have a look at this, come back to me if you have any questions. That might be an approach to take in a less, intense life or death situation.
So I think that it's leaving the door open is really important. So consent is a process, not a one-off event. So you can come back and do it another time if that's a possibility. Taking good notes. The notes have come up in a couple of questions here. Taking good notes. The fact that this was offered and declined, that you've offered them opportunities, you've tried to explore it. The GMC actually cover this in their consent guidance. It's one of their sections about what to do. So I think on the next slide, I've got a couple of QR codes, which I might just share. In fact, Cam, can you just move me over to control the presentation just so I can put the next slide up with the QR codes on it for the people in the audience to get the information. So you should be able to hope to see some QR codes there. Can somebody tell me? Can you see them?
I can see them.
Great. So there's the GMC consent guidance on the left. There's Montgomery. I know it's a bit old. It's 8 years old, 9 years old now, but it's a really good. It's a good read, and it's worth, I think, reviewing to give you a background. There's a link to a description of McCulloch as well, just for your information. I'm gonna go on because we're getting short of time. There's a question about documentation, and I think that so what would be good practice about documentation? I think it's documenting the relevant parts of the discussion that you've had with the patient, because you will have consent conversations with patients on a daily basis in some types of jobs. You will not remember what you said and what you specifically responded to in terms of questions that they had. So it's writing down what their concerns were, what information you gave them, keeping a copy of any information leaflet would be relevant, and saying that you'd given them time to ask questions and that you discussed doing nothing would be examples of things that might be recorded. It's impossible to record everything. Obviously, it's a counsel of perfection to do anything else, and the GMC and courts, I think, recognise that. I'm going to read out one question here as it comes from the doctor. Despite use, many doctors involved with major interventions will be aware that regularly, but infrequently, previously unrecognised complications arise. So whilst the nature of such a complication cannot be foreseen, new complications occur regularly. How do you view the idea of explaining that to people as well as recognised complications, or explain to people as well that unforeseeable complications may also occur? I'm sorry if I mangled your question, Doctor. Thea, does that make sense? So we would often see new issues arising in old operations, or things that we'd not really previously come across, and trying to work out what was going on with that would sometimes be quite difficult. So I would leave it open and just say, look, these are the things that I know about. These are the risks that I'm aware of. These are this is my own practice. This is what the publications would suggest. But there are things that I can't predict that could happen. That's what I would do. Would that be reasonable, or would you have another suggestion, Thea?
I think that's absolutely reasonable. And the thing to bear in mind when you're considering about unknown risks is the court has given guidance on this. This is the Court of Appeal in Deuce, which one of the cases I mentioned in 2018. I
was referring to Deuce in the question specifically.
Yeah. So that was it was a hysterectomy and oophorectomy, and there was chronic pain as a result. And the court said that in 2008, a reasonable body of gynecologists just didn't know that was a risk. Now, by 2018, that was something that was as standard in informed consent, and the risk of the developing chronic pain was a very well-known risk. But back then in 2008, it wasn't. That was not a breach of. That was not a failure to obtain informed consent. So from a legal point of view, I don't think you have to say anything, but my personal view would be best practice would be to do exactly what you've suggested, Jerard. And just to go back to your last point, I would agree on documentation. The more you can write down with the time you have available, the better for us lawyers. If I see someone saying, risks, benefits discussed, that's great. It's far better than saying nothing. If I have details of those risks, that's even better. If I have details of including saying nothing, that would be wonderful as a defendant barrister to be able to point to in the medical records. It's not something we see very often. Sometimes you have covering letters afterwards, which is also helpful, which go through the risks. That's also useful. And writing down which leaflets you gave to a patient is also helpful.
Look, Tia, I think we're going to have to call it there. There are a whole heap of questions. I'm really sorry, everybody, because as often happens, a lot of the questions came in very late, which means it's really hard for us to get to them. And some of them are very interesting questions, so I apologise if we haven't managed to get to them. Tia, thank you so much for taking time out and missing bedtime with the children as well to come and talk to us. So thank you very much for doing that. I hope they're asleep by now.
I can't hear anything. I've got 3 little boys, so I would hope be able to hear if it was a disaster.
Okay, well that's great news, and thank you everybody for coming to listen to us talking on a Tuesday night. I hope the rest of the summer improves from where it is currently. Good night.
Thank you.